this evening. And oh, that didn't work well. And thank you all for being here tonight. First of all, my name's Jeff Miller, and I do work at Disability Rights Texas. And if you're not familiar, Disability Rights Texas is the state's designated protection and advocacy agency for people with disabilities. And what that means is that we get some federal funding to help Texans with disabilities access services and protect their rights. So if people need to find some kind of long-term services or something like that, we can help with that. Or if someone is being mistreated or not treated because of their disability, we have attorneys and advocates that can work on that too. And I always mention Disability Rights Texas just because we are a statewide organization. We do handle all kinds of disabilities and all kinds of disability issues. And if we can't take someone's specific case and provide personal case services, we do a lot of information and referrals. So if we can't help you specifically, we can probably point you in a direction that might give you some help. And the other really neat thing is we don't charge for our services. So if you ever have a specific issue and you're not sure if you need someone to represent you or to help you, it doesn't hurt to give us a call and we can talk. That said, I am a policy specialist at Disability Rights Texas now. I often say that I'm a recovering attorney because in a former life, I was an attorney in private practice and practiced law for a number of years. But for about the last 15 years, I've been doing public policy work. And that means that I specifically work with our state agencies like the Texas Education Agency and the Texas Workforce Commission and Health and Human Services, and our state lawmakers, our state representatives and senators, to look at policies and laws that impact Texans with disabilities and try to help them make those laws and policies better. Because just between you and me, there are lots of policies and laws in Texas that impact people with disabilities that could be made better. So that's what we've been working on. And so at Disability Rights Texas, I work mainly on the areas of voting rights, guardianship reform, and transition and special education. But I do a little bit everything. The last thing I want to say, because I think it's really important, especially with talking about what we're going to talk about tonight, aside from being an attorney that's worked in the advocacy world for a number of years, I'm also the very proud father of a 21-year-old with developmental disabilities. And so not only do I get to help make the laws, I get to live them out every day. So that said, as we go through this, there's going to be a lot of information. Hopefully, I'll do a pretty good job of explaining to you what the issue is so you can think about it and get more information later if you need. But don't be afraid to jot down your question if you have it, and we'll talk about questions at the end. So let's get started. What we're going to do in the time that we have this evening is talk real quickly about the idea of self-determination and why that means, and hopefully it'll become apparent in a minute why that's important. Then we're going to talk generally about what guardianship is and the requirements for guardianship in Texas. We're going to talk about how Texas is in the middle of reforming the way that guardianship works in Texas and what that means. And then finally, we're going to discuss specifically some alternatives to guardianship and some supports and services that are available to folks with disabilities to meet their support needs. And finally, at the end, we're going to talk specifically about one of those alternatives to guardianship called supported decision-making, which is a fairly new concept that I want to make sure everybody's aware of. So let's get started. So like I said, when you're talking about guardianship, you've got to start with the concept of self-determination and what that means. And it all comes down to choices, because if you think about it, our rights really equal choices, because we have rights, because to have a right means that I have a choice to either do something or not do something. And so choices are the whole point of self-determination. And self-determination really is all about life control, because self-determination is basically the concept of having the feeling that you have some control over your life. And if you think about it, I mean, we all want to be able to practice this self-determination. Because I know in my life, if I feel like I have some say in what's happening to me and what I am supposed to do or not do, or those sorts of things, I feel a whole lot better when than I do if I feel like I don't have any choice, that someone else is determining everything in my life. And so that's what self-determination is all about. It's that concept of having the ability to have a say in your life. And there are studies that show us that if people feel like they have control over what's happening to them, they're healthier, they're more independent, they're more well-adjusted, and all those sorts of things. So with the social scientists tell us that it's really important to feel like they have control over their lives. And so it's important for us to allow other people to make choices that they're able to make. The one caveat, though, to self-determination, if we really believe that people should be able to control their lives to the greatest extent appropriate, is that that means that we have to allow people to make decisions that we wouldn't necessarily make. And it's this concept known as the dignity of risk. So if I really believe that my son has the right to make his own choices now that he's an adult, then I have to live with him making those choices, whether they're choices I would want to see him make or not. Now, I'm not talking about something that could potentially harm him, but I'm talking about just being able to make the choices that he wants to make. And if you think about it, that's how we learn, is by making choices and seeing what happens as a result of that. And if it's a good thing, hopefully I'll do it again. And if it's a bad thing, hopefully I won't. But that's the whole point behind self-determination and this idea of the dignity of risk. So I go through all that because when we think about guardianship, guardianship is really about choice making, because the concept of guardianship exists because in a guardianship situation, we're asking a court to appoint someone to make decisions for an individual with a disability. And so when we think about guardianship, we have to continue to think about self-determination and choice-making and those kinds of concepts. So when we think about guardianship, and you can think about, why is it that we consider guardianship for people that have support needs? Well, one reason is that when a student reaches the age of 18, I'm sure most of us know, if a child is in special education and they turn 18, the rights that parents have to make educational decisions transfer to that 18-year-old student. And so 18 is a time when lots of families in the state start thinking about whether or not guardianship would be appropriate for their loved one. And oftentimes, it's around that time that either someone from a school or their physician starts to talk to them about long-term things like guardianship and what that means. There's also lots of people think that guardianship is necessary to help access services or to protect adults with disabilities and that sort of thing. And there really are some other things and other ways to take care of those issues. And one of the other really big reasons that a lot of us think about the idea of guardianship is that because we love our loved ones, we want to protect them, and we are really concerned about exploitation, specifically and mostly economic exploitation. And we think that guardianship can help with that. And in some cases it can, but just remember that even people with a guardian can be taken advantage of. So hopefully we can talk about in a few minutes some other things that are more specifically could be used to help protect from the idea or potential of exploitation. The other thing to think about when we think about guardianship is, what does it do? Well, a guardianship, when we think about guardianship, most of us have this idea that, a guardianship is when someone that's not able to meet their needs is appointed by a court, an individual, to take care of those needs for that person with a disability and make those decisions for them. And that's true, but guardianship also removes a person's right to make choices about their lives. And that's a big deal. And it's something that shouldn't be taken on without giving it a lot of thought. And that's why I'm glad that you all decided to be here this evening, so that we can talk about the big picture, about what guardianship is and what some alternatives to guardianship are, so that you're aware. And I guess before we go on, I should let you know that it's not the position of Disability Rights Texas or me personally that nobody ever needs a guardian, because of course there are people that do and will need a guardian at some point in their lives. It's also not my position that everyone needs a guardian, because obviously there are people that with proper supports can take care of their needs and make their own decision. What I do believe, and what Disability Rights Texas does believe, is that guardianship is a very personal, very fact-specific decision that families have to make. And we believe that the more information that families have, the better position they're in to make the most appropriate decision for their loved one. So that said, we'll go on. One other thing just to remember about guardianship is that a guardianship is a creation of the courts. A court creates a guardianship, a court has oversight over the guardianship, and a court maintains responsibility for that guardianship. So once a guardianship is established, it's going to be established until someone goes back to court and changes things. So once the guardianship is in place, if you ever want to change who the guardian is, if you decide out over time that someone has more ability than we thought at first and wants to have some or all of their rights restored, that all requires going back to the court and talking to the court and asking them to make that change. The one other thing that I will mention just about the concept of guardianship is that guardianship can be expensive, because guardianship is a creature of the courts and attorneys are involved. It can be expensive. The average cost of a guardianship in Texas is between $3,000 and $7,000, depending on where you are and what the situation is. So it's just something to think about. So we've talked generally what guardianship is, but what is guardianship specifically? And so when you're talking about the legal definition of a guardianship in Texas, guardianship is a process where a court determines whether or not a person is incapacitated, which is the legal term. And in Texas, an incapacitated person is someone that, due to a physical or mental condition, is unable to manage their financial affairs, care for their physical or mental health, or provide food, clothing, and shelter for themselves. If someone is unable to do those things, then a court can declare that they are incapacitated. And once they make that determination, then they will appoint a guardian to make any or all of those decisions for the individual with a disability. Now in Texas, there's basically two types of guardianship. There's a guardian of the person and a guardian of the estate, and they are basically what they sound like. A guardian of the estate is someone that's responsible for the financial assets of an individual with a disability, and a guardian of the person is responsible for the day-to-day activities of the individual or needs of the individual. A guardian of the person or a guardian of the estate can either be what's called a full or total guardianship, where all of an individual's decision-making rights are taken away and given to the guardian, or, as in most cases, they can be limited. So a court can find that someone is able to make decisions about everything except they need help to make medical decisions, or they need help to make financial decisions. And so the court would appoint a limited guardian to take care of those things. So, so that's the concept of guardianship, and the way that this works is that on or before the time that the individual with a disability is 18, the person that wants to be guardian would hire an attorney, and then the attorney would file an application for guardianship. The application would be filed in the county in which the person with a disability lives. And so the application for guardianship is filed there along with the medical report, which is called a Certificate of Medical Examination, or CME. And this CME is a report by a medical doctor, or if you're talking about someone that has an intellectual disability, it can be done by a licensed psychologist. And this report tells the court about the ability of the individual to make their own decisions and the kinds of support that they need, and also whether the condition that somebody has is likely to be permanent, or if it could change over time, and if the court needs to review it at some point, and those sorts of things. The court will also then appoint what's called an attorney ad litem. And the attorney ad litem is the attorney for the individual with a disability. And their job is to represent what it is that the individual with the disability wants. Along with the attorney with ad litem, the court will also appoint, in most cases, a guardian ad litem. And the guardian ad litem's role is to look at all of the situation and all the information filed by everyone, and try to figure out what they think is in the best interest of the individual with the disability. And they will give a report to the court. And once they've done that, then a hearing will be held. And the hearing will be held and witnesses will be called, and the person with the disability may or may not be there depending on what's appropriate. And evidence can be presented. And at the end of all of that, the court will make a determination whether or not the individual is incapacitated. And if the court determines that the individual with a disability is incapacitated, the court will decide what rights the individual with a disability retains and what rights will go to the guardian, and the guardian will be responsible for. After determining that, the court will then appoint someone to be guardian for the individual with a disability. Just a couple of quick notes about being a guardian. The court has continuing oversight and responsibility for the guardianship. And so it isn't like you go to the court once and you're done with your interaction with the court, unfortunately. There is a report that has to be filed on an annual basis with the court. And this is a status report. If it's a guardian of the person, it's an accounting. If it's a guardian of the estate, and that gets filed with the court on a yearly basis. And once that's filed, the court will review that report and determine whether or not there is some reason for to have a hearing or to look at any issues with that guardianship. So that's generally the way the process works in Texas. So a few years ago, there were a group of people that got together, a group of people with disabilities and family members of people under guardianship and guardianship attorneys and disability advocates and representatives from the aging population and some probate judges, and started looking at the guardianship process and trying to figure out what could be done to make guardianship work better for people with disabilities and their families. And one of the things that was determined was that the process was just way too complicated for a lot of people, wasn't very uniform across the state, was too expensive, and didn't do a good job of protecting the rights of people with disabilities. So this group decided to put forth some ideas to change the way that we think about guardianship, and at the same time change some of the processes and ways that we administer guardianship in Texas. One of the things that was done was that we decided that we really wanted for people to start thinking of this idea of person-centered thinking. And so the guardianship process isn't really about guardianship, it's about support. It's about trying to figure out how to make sure, because if we remember, in a guardianship proceeding, a court's trying to determine whether or not someone is incapacitated. And so that means, can they make decisions about their needs? And so we determined that one way to think about guardianship and alternatives to guardianship was to start by looking at a person as a person and not as a diagnosis or not as a disability. And so the concept, you're probably aware, of person-centered thinking is just that. It's looking at the whole person and not focusing just on fixing what's wrong. And the concept behind person-centered thinking is to identify the needs of an individual with a disability, but not just those things that are important for that person, like their medical needs and their financial needs and their educational needs, but also looking at what's important to that person. Where do they want to live? Who do they want to live with? What do they want to do with their day? And so it's really important to consider all of that when we think about someone's support needs. But once we've determined what somebody's support needs are, then our concept with guardianship reform is really to look at, is there a way that we can meet, once we've identified that specific support need of that individual with a disability, what do we have available, either as a program that's in the area or a support of some kind, or is there a legal document that could be used to help meet that need, short of having to have a guardian appointed by a court to meet it for them. And that's what the idea of guardianship reform in Texas was built on. So in the 84th legislature in 2015 adopted a series of bills that changed the way we think about guardianship in Texas. And they had to do with the Alternatives to Guardianship Bill and a Supported Decision-Making Agreement Act and a Bill of Rights for people under guardianship. The number one biggest change that was made during that legislative session and the change that we've made to our guardianship process is that now courts are mandated to consider alternatives to guardianship and supports and services before they can create a guardianship. So what does that mean? That means, going back to our concept of person-centered planning or person-centered thinking, is that if a person has a need to take care of their food, clothing, and shelter, or their medical needs, or their finances, is there something like we just talked about, an alternative of some sort to a guardianship or a support and service that could be put in place to meet that need. If there is, then the law now says that it would not be appropriate to have a guardianship. And it helps me to kind of think of it this way. When we're talking about support needs and decision-making for people with disabilities, it's a continuum. It's not an all or nothing kind of thing. It isn't that either someone has a guardian or they get nothing. It's all about trying to figure out what is the need we're trying to meet and how can we do that. So for some people, they have support needs, but they're able to meet that all by themselves and they don't need anything. Other people have support needs, but those needs can be met with supports and services that can be put in place. So they still don't need a guardianship. Some people may be able to meet almost all of their needs, but may need specific help in one specific area, like their finances. So a limited guardianship may be appropriate. And there are some people whose support needs are so significant that they really do need somebody appointed as a guardian to meet those needs. But I think if we think about it like that, that it's a continuum, it's not a guardianship or no guardianship, it's a what does this person need? It's easier for me to try to figure that out and to think about it that way. Like I said, we also became the first state in the country to codify supported decision-making in statute, and we put together a Bill of Rights for people under guardianship. So real quickly, we're going to talk about some of the alternatives to guardianship, since now courts have to consider those things. We're going to talk specifically about what is included in those kinds of things. So alternatives to guardianship are legal documents that give another person the right to make decisions for the individual with a disability. And so when we're talking about these, we're going to be talking about powers of attorney, which you're probably aware of. Now, power of attorney is a way for me to give someone else the right to make decisions for me. So we specifically have a medical power of attorney in Texas, which would allow me to let someone else make medical decisions for me if I can't. So that's comes in really handy for lots of reasons. There's also a durable power of attorney. And a durable power of attorney says that I can give someone else the right to make choices or decisions for me in just about any area that I have a need in. So I can have someone have an educational power of attorney and make education decisions for me, or financial decisions through a financial power of attorney. Or I can have someone that can make decisions about where I work and how I work and those kinds of things. So powers of attorney can be just about whatever is needed. The things to remember about a power of attorney, though, are that while I give someone else the right to make decisions for me, I can still make decisions for myself. So this doesn't take away my right to make my own decisions. And a power of attorney can be revoked at any time. So if I give you my power of attorney and then I decide I don't want to do that anymore, I can revoke that power of attorney and you would no longer have that power. We also have something called a Declaration for Mental Health Treatment in Texas, which is a way for me to, if I have a history of mental health episodes, I can in advance designate what kinds of treatment that I want and what kinds of treatment that I don't want, to make it really clear if I ever have a mental health crisis. As we talked before, or as I said before, one of the main reasons a lot of us consider guardianship and the need for that is a concern about our loved one being able to handle money and to not be financially exploited. So there are some things like the representative payee program under the Social Security Administration that would allow, if someone's receiving Social Security benefits, to have someone else receive that money for them and help them deal with that money. Things as simple as having a joint bank account where there's two names on the account and your loved one can't withdraw that money unless you agree with them or something like that. That can be used. Um, just as an aside, when we're talking about meeting someone's needs, we sometimes have to get creative. And we're not tied to any one of these kinds of things. So like with a joint bank account, my son has a job, has had a job for a while, and he has a bank account. And it's not a joint account, but I have access to his account, so I can check it periodically just to see if anything different is going on. And if I see something different, then we sit down and talk. So it's all about that person-centeredness of what are the needs that my son has or my family has, and how do we meet that need? And you're probably aware of special needs trusts. It's another way to save money for the benefit of someone with a disability. So if I have money in a special needs trust for the benefit of my son, then if the money that's being saved for him won't impact his ability to qualify for Social Security benefits or that sort of thing. So that's very quickly, that was alternatives to guardianship. And so the other thing that the court's going to be looking at now are supports and services. So what does that mean? Well, supports and services are formal and informal resources and assistance that help an individual to meet their needs. And you can see the need. I mean, it's basically looking at the definition of what incapacity is, and if there's some way to meet those specific needs that someone has to keep them from being declared incapacitated, that would be a support and service. So when we talk about supports and services, what are we talking about in reality? Well, our community, my friends, my family, those people that I work with, those are supports that I can have that may be available in my life to help me meet some specific needs. One of the other very common supports that's out there for some people are Medicaid waivers. And so if you're familiar with things like the CLASS program or the HCS program or STAR Plus, these are comprehensive Medicaid waivers that provide long-term services and supports to qualified people with disabilities. There are programs through the state, some of them Medicaid-based, some not, that provide case management services. And this is a way to have someone help coordinate all the different support needs of the individual with a disability and figure out how to make sure that those needs get met. We've talked about person-centered planning and how that can be used to help meet the needs of someone. Because in person-centered planning, first we identify all the specific needs someone has, and then the other part of that planning is to identify a way that those needs are going to be met. And then the rest of these, some are statewide ideas, some are local ideas. Again, it gets back to being creative. But after I've identified what their needs are, what those needs are, then I come up with solutions. And so are there free or reduced price meal programs or food programs or prescription programs in my area? Are there transportation programs like taxi vouchers or public transit or those sorts of things that my loved one qualifies for or could use? In my area, are there home visitation or daily call services to help with people? What programs does my utility company offer? For example, my utility company has a program that when my son moves out on his own in his own apartment, if he should ever have an issue where his bill doesn't get paid before terminating the service, they will notify me and let me know, and those sorts of things. Technology is growing by leaps and bounds all the time, and from smartphones to tablets or whatever, there's lots of things that if I have specific needs, medical needs or whatever, that technology might be a way to deal with. And then we've talked about some of the things that can be in place to help with financial issues. So again, that was really quick, and just wanted to give you an idea about some of those things that are out there, supports and services that may be available to an individual that has needs. So one of the things and one of the alternatives to guardianship that we talked about was this idea of a supported decision-making agreement. And what is supported decision-making? Well, hopefully everybody is familiar with a supported decision-making agreement now. But if you're not, supported decision-making is when a person with a disability and one or more of the people that they trust enter into an agreement whereby those supporters will help the individual with the disability to make decisions in one or more areas of their lives. So a supported decision-making agreement is basically a relationship between the individual with the disability and someone that they know and trust. And so they enter into this agreement. And so whenever if I have someone that is going to be my supporter for making medical decisions, we would enter into a supported decision-making agreement. And then when I go to the doctor, my supporter may or may not, depending on what I think I need, would come along with me and help me understand the decision that I've got to make, understand the choices that I have, and help me make that decision. So that is what supported decision-making is really about. So it's all about having someone in my life to help me understand options and responsibilities and consequences, help me find information, and help me communicate that to other people. So a supported decision-making agreement is a simple agreement. It basically is a form that is filled out that has information about the supporter and the person with the disability. It has a place for the person with the disability to indicate the areas of support that this person is going to help them with. And then it's signed by both the individual with the disability and their supporter. And it's either witnessed or it's notarized, and then it's in effect. The law says that anyone that is 18 years old or older and has a physical or mental impairment that substantially limits one or more of their major life activities can use the supported decision-making agreement. The law also, while it doesn't specifically tell us the kind of capacity that an individual needs, a person does need to be able to know that they're asking someone else to help them make decisions and be able to communicate what those decisions are to be able to use the supported decision-making agreement. So it isn't for everybody, but a lot of people can use supported decision-making in their lives. And to be honest, if you think about it, most of us use supported decision-making in our lives right now. We just don't call it that. I know that whenever I'm going to make a big purchase, or maybe even a small purchase, if I'm going to get a new phone or whatever, I'm going to talk to my friends and family members and say, hey, I'm thinking about buying this. What do you think? What have you heard? Even if I'm going to go see a movie, I'm probably going to ask somebody else, have you seen it, or what do you think about it? I mean, those are all of our ways of using supported decision-making, because we're getting input from other people to make decisions about our lives. And then we use that to make that decision. Just in terms of who can be a supporter, the law says any adult can be a supporter in Texas. But it's got to be someone that the individual trusts. So it's typically going to be a friend or a family member, that sort of thing. The big thing to remember about supported decision-making, though, is that it is the person with the disability in a supported decision-making arrangement that makes the decision. The supporter is only there to help them find that information and understand what those decisions there are, and to communicate that information. The other thing to remember about supported decision-making is it's voluntary. So the person with the disability or their supporter can end the arrangement at any time. And not only is it voluntary, It doesn't mean that you have to go to court. A court doesn't have to see the agreement. You don't file the agreement with the court. This is a contract, in essence, between the individual with the disability and the person that is supporting them. The big difference between a supported decision-making agreement and a power of attorney, because oftentimes that comes up, is who gets to make the final decision. Because in a power of attorney situation, I can give you the ability to make decisions for me. With a supported decision-making agreement, you support me to make that decision. You can help me, you can give me ideas, but ultimately only I can make that decision. That's the big difference. And we've talked about what a supporter does. Finally, I'll just say that supported decision-making, we are really excited about it because it's a way for someone to get help to make decisions that they can make that are appropriate for them without having to give up their rights. But on the other hand, in some ways, supported decision-making is a lot of work because it means I have to invest in helping this individual that I've agreed to help, helping them understand things and get information and do all those things. But the fact that by doing that, I'm helping someone preserve that self-determination in their lives makes it all worth it. So I think you have access to the PowerPoint. There are some resources there. And the last thing I will say is that at Disability Rights Texas, we have developed this toolkit around supported decision-making and alternatives to guardianship. It basically covers a lot of the things that I've talked about this evening in a lot more detail. There's more information about specific supports and services in Texas. There's also sample forms of a lot of the alternatives to guardianship that we talked about. These are links to that. On the Disability Rights Texas website is this toolkit in English and Spanish. So feel free to look at it and download it and use it if it would be helpful. So anyway, that was a lot of information really quickly, but I wanted to save a little bit of time for questions. And so if someone's got